Good afternoon, guys. I'm Advocate Sanjay. Today I'm discuss about the Order 27 Rule Number 9 CPC application for appointment of local commissioner can be made even before the commencement of trial. The judgment passed by the Kerala High Court. The Kerala High Court has made it clearly that application made for the appointment of commissioner for local inspection under the provision 26 rule 9 of a code of civil procedure can be made either before the commencement of trial or after. The single judge benches of Justice Anand Ramannath Hegde said the provision is not stage centric, those the provision can be invoked either before a commencement of the trial or after. Further, the court clarified that the appointment of commissioner for the local inspection or scientific forensic investigation expertise opinions is intended to secure the evidence, and the same is not only permissible but also desirable in certain cases. The bench gave the clarification while allowing the petition filed by one Sadr Shatkashan sitting aside order passed by trial court by which he rejected the application made for appointment of commissioner for local inspection of the LSLE encroachment on the Sool Road. The trial court had rejected the application on ground that the application filed before the complaints of trial is mature. The respondent had opposed the appeal's content. It was impermissible for appointed of a commissioner for local inspection in a suit seeking a relief of permanent injunction, whether if a commissioner is appointed and the report is secured and the same amount to collection of evidence, which is also imperative. Finally, it was submitted that the application of local inspection before the completion of trial is not contemplated in the scheme of Order 26 of Court. The court referred the Order 26 Rule 9 and 10b of the Code said the very purpose of Order 26 of Code is to secure evidence. Those the content said commissioner cannot be appointed for local inspection and the resources amount to collected of evidence overlook the provision, namely Order 26 Rule 10 of the Code. Further, it said the report of court commissioner would be documentary evidence. Under the Indian evidence, the party to suit is entitled to protect documentary evidence in the supporting of his cases, subject to process to relevancy of documents added. The party sued in an appropriate proceeding and unable under the law to prove his case through the report of commissioner. In a given case, that the call for the appointment of commissioner, if application is rejected, the same amount to be denial of permission to lead evidence. The bench also opened the report given a striction complexity of matter in case may go a long way in arriving at just decision, assisting the court appreciating the order evidence on record of fact situation in the proper perspective. If report of commissioner has nothing to do with the subject matter in dispute, then there cannot be order appointed a commissioner. Order appointed a commissioner can be made only if the commissioner report become a relevant piece of evidence. Then it held the report based on local inspection will be handily to decided the case related to encroachment. In a case on hand, the petitioner to prove his assertion of encroachment insist leading oral evidence of witnesses has applied for local inspection, and the same is not only permissible but also desirable. Nothing that the decision has to when the report of commissioner is to be secured must be taken having due regard to facts and circumstances. The bench expressed the discretion sought lie with the court as to point the commissioner before the trial. After the trial, the decision must be taken with due regard to possibility reduction and eliminating the need to record the oral evidence of witness to proving an issue which could be factually decided with the edits of report. In edited in given case, the appointment of commissioner before the commencement of trial may facilitate a focused trial. Then it held, considered the nature of case, the court is of a view that an order rejected the application with the liability of file an application for local inspection after the trial is nothing but place the carter before the horses. Finally, the court made it clearly that the power of court to appoint a commissioner is not controlled by the forum of suit is held. The language of provision is clearly it does not impose any such restriction based on the forum of the suit. The guiding factor in whether the report is necessary for the elucidated matter is dispute. It can be any kinds of suit. Miss it suit for the injunction, mandatory injunction, declaration, injunction, position, partition, specific performance, and any suit for that matter. It concluded by saying the burden of proving the allegedly encroachment is on a plaintiff. Insist of volume oral evidence. If a petitioner seeking to prove his contents related to encroachment through the report of commissioner, the payer for the local inspection should be willingly granted unless there is justification reason for the court to take a view that the local inspection is fluidly exercised. For this reason, the court is of the view that trial court committed a grave error is not appointed a surveyor for the local inspection. Accordingly, it's allowed the petitioner directed to trial court to appoint a judicially survivor to measure the suit property and to secure. Thank you, everyone.